Section 174 of the Companies Act 2013. Quorum. Meetings of the board. Section 174. So what is a quorum? Number of directors to be present at the meeting. Minimum number. Quorum is the minimum number of qualified persons who must attend in order to transact business at a duly convenient board meeting. A meeting shall not be deemed to have been properly held unless quorum was present at that meeting. So quorum is minimum number of members or directors in this case. To be present in the meeting. Then only it will be valid meeting. Section 174 of the Companies Act 2013 provides quorum for a meeting of the board according to this section. The quorum for a board meeting shall be 1/3 of its total strength or 2 director, whichever is higher. So 1/3 or 2, whichever is higher. What about the fraction? Fraction should be considered as 1. This is as per SS1, Secretarial Standard 1. The directors who participate by video conferencing or by other audiovisual means shall be counted as for the purpose of determining the quorum at the meeting. Yes, video conferencing or any other audiovisual will be counted for quorum. Further, the explanation as given in Rule 3 of the Company's Rules, Meetings of the Board and its Powers, provides that the director participating in a meeting through VC or other AV means shall be counted for the purpose of quorum, unless he is to be excluded for any item of business under any provisions of the Act or the rules. Wide notification. 5th June 2015, Section 8 of the company shall constitute a quorum for the board meeting 8 members or 25% of its total strength, whichever is less, provided that the quorum shall not be less than 2 members. So, notification. As per notification, for the Section 8 companies, what is the quorum? It will be 8 members or 25% of total strength, subject to at least 2 director to be present. Minimum quorum 8 or 25% of total strength, whichever is less, but the condition at least 2 director is required. provided the quorum shall not be less than 2 members. The continuing directors may not withstanding any vacancy in the board, but if and so long as their number is reduced below the quorum fixed by the act for a meeting of the board, the continuing directors or a director may act for the purpose of increasing the number of directors to the fixed for the quorum of summoning in a general meeting of the company and for no other purpose. So, in case of vacancy, cannot be counted for the quorum in case of the total strength, and if it is below minimum number as per the act, then that is as per the act fixed number is there, no, below that, then we can make the quorum even if one member to increase the number of directors as fixed by the act. So only this transaction can be done in if the minimum quorum is not present. So in case of number of existing directors is reduced below the quorum fixed by the act for a meeting of the board, the continuing directors or even a single director may form a quorum for the purpose of increasing the number of directors to that fixed for the quorum or of summoning or a general meeting of the company and no other purpose. Where at any time, here is mentioned, for no other purpose. Where at any time the number of interested directors exceeds or is equal to 2/3 of the total strength of the board of directors, the quorum shall be number of directors who are present at the meeting and not interested directors and are not be less than 2. True. Not less than the 2. If the interested directors are 2/3 or more, then disinterested directors or a 2, minimum 2 is required for the quorum. Quorum shall be the number of directors who are present at the meeting and not interested directors and are not be less than 2. Interested director for the purpose of this subsection means a director within the meaning of section 184 subsection 2. Under this section, interested director means every director of a company who is in a way whether directly or indirectly concerned or interested in a contract or arrangement or a proposed contract or arrangement entered into or to be entered into with a body corporate in which such director or such director in association with any other director holds more than 2% shareholding of that body corporate or is a promoter, manager, executive officer of that body corporate. So section interested director. So the first point is with a body corporate holding 2%. body corporate holding more than 2% of shareholding, or a promoter is a promoter, officer, director, chief executive officer, manager of that body corporate. With a firm, partnership firm, or other entity in which such director is a partner, in case of entity owner or a member, as the case may be, shall disclose the nature of his concern or interest at the meeting of the board in which the contract or arrangement is discussed, and shall not participate in meeting. So in case of a firm or entity is a partner or a owner or a member of such entity cannot participate in the meeting. However, where any director who is not so concerned or interested at the time of entering into such contract or arrangement, he shall, if he becomes concerned or interested after the contract or arrangement is entered into, disclose his concern or interest forthwith when he becomes concerned or interested, or at the first meeting of the board held after he becomes so concerned or interested. Here 3 is mentioned. 3, where at any time the number of interest director exceeds, if it interest director exceeds 2/3, then it will be at least 2, right? What is that means? In case of specified IFSC public company, IFSC private company, section 174 subsection 3 shall apply, with the exception that interested director may participate in such meeting provided the disclosure of his interest is made by the concerned director either prior or at the meeting for IFSC public company or IFSC private company. Thus, quorum of the board meeting, it should be at least 1/3 of the total strength, or 2 director, whichever is more. Whichever is more or whichever is higher. Notification. Section 184 subsection 2 shall apply on private company, with the exception that the interested director may participate in such meeting after disclosure of his interest. But in the case of public company, it cannot participate in the meeting at all. But private company, it will be after the disclosure of interest, he can participate. So for private limited company, interested directors, correct? So interested director will also be included for the purpose of quorum, right? But they have to disclose the before the meeting. And one more thing, exemption available, this exemption available only if they are not defaulted in filing annual account or annual returns. Annual accounts or annual records. Next comes, meeting could not be held for want of quorum. Where a meeting of the board could not be held for want of quorum, then unless the articles of the company otherwise provide, then meeting shall automatically stand adjourned to the same day at the same time and the same place in the next week, or if that is a national holiday till the next succeeding day which is not a national holiday at the same time and the place. So meeting could not be held meeting could not held for want of quorum. Shortage of quorum. Want of quorum, then it will be adjourned next week, same place, same time. So next week, same time, same place, same day. If that day is a national holiday, then next day. What about the public holiday? Yes, public holiday can be done. National holiday cannot be. Exception. The provisions of the section 174 are not applicable on one person company in which there is only one director. Exception, one person company. For the purpose of calculating quorum, any fraction of a number shall be rounded off as 1. Total strength shall not include the director whose place are vacant. Example, discussing the following situation with respect to the quorum. There are 9 directors in a company, and out of 2 officers of the directors have fallen vacant. So according to section 174 subsection 1 of the Companies Act, quorum is 1/3 of the total strength of the board. Any fraction contained said 1/3 being rounded as 1, or 2 director, whichever is higher. Total strength is to be derived after deducting number of directors whose office are vacant. This is the point. Therefore, where the total number of directors is 9 and the 2 offices of the directors have fallen vacant, we find 1/3 of the 7. 1/3 of the 7. So director, which will be rounded up as 3. 1/3 of the 7 being higher than 2, therefore 3 directors would constitute the quorum. Minimum will be 3. 2 or 3, whichever is higher, 3 directors would constitute the quorum for the board meeting. There are 15 directors in a company. During discussion of the particular item, the 13 of them directors are said to be interested within the meaning of section 184 subsection 2 of the Companies Act. What will be then? At least if it is more than 2 by 3, then it will be at least 2 directors will be the quorum, unless under section 174 subsection 3 of the Companies Act, if at any time the number of interested directors exceeds or is equal to 2/3 of the total strength of the board of directors, the number of directors who are non-interested but present at the meeting not being less than 2 shall constitute the quorum. Accordingly, in the given problem, there are in all 15 directors. The board meeting commences with all 15 directors. During the meeting, an item comes up for the discussion in respect of 13 which happen to be interested directors. In this case, in spite of the excess of the interested directors being more than 2/3, the prescribed minimum number of non-interested directors constituting the quorum, namely 2, are present at the meeting and can transact the particular item of business. Last point in the quorum of the meeting, section 174. A meeting of board of no holiday limited was held on holiday on account of Ganesh Chaturthi. However, due to lack of quorum, the proceeding of the meeting could not be held, and therefore the chairman of the meeting decided, with the consent of the majority, that the board meeting be adjourned to the next week on the same day. However, that fixed day for the adjourned meeting happens to be Sunday. Whether the adjourned meeting of the board can be held on a Sunday. When a board meeting is adjourned due to lack of quorum, then under section 174 subsection 4, the adjourned meeting can be held on the same day at the same time and the same place in the next week, or if that day is a national holiday, till the next succeeding day, which is not a national holiday, at the same place at the same time, unless articles provides otherwise. Since the section specify the exclusion of only national holiday, so any original adjourned committee meetings can be held on Sundays and other holidays except national holidays. So meeting can be held on Sunday. So Sunday is not a national holiday, it is a public holiday. Even though it is a public holiday, it can be done. Only in the case of national holiday, it will be succeeded to next succeeding day. Quorum shall present at every stage, else business is not said to be validly conducted. The meeting, when got adjourned for the want of quorum, will be counted for the purpose of number of meeting. However, the continuing meeting will not be counted once again. When the directors abstain from voting, do not count them in the total number for the counting votes cast. So resolution is said to be passed means votes casted in favor shall exceed the votes cast against. When the position of director is vacant, do not consider the vacancy in total number of directors. We all know that the board resolution needs majority of votes to make business pass. That is not the given in the act. You can read regulation number 68 of the table F of schedule 1. So majority will be the, if resolution needs majority, then favor vote will be higher than the against. National holiday, Independence Day, Gandhi Jayanti, such other holiday. Sunday will be public holiday. Can be want of quorum. Yes, done. That day meeting can be done. So this is with regard to section 174, want of quorum. Quorum for the meetings of the board, section 174. Minimum number of directors to be present in the meeting, 1/3 or 2, whichever is higher. Fraction shall be considered as 1. Video conference or any other AV means shall be counted for the quorum. Notification, section 8 or 25% of total strength, whichever is lower, at least 2 director is required. Vacancy shall not be considered for the total strength for the calculation of quorum. Below minimum number as per the act, that is, the quorum can be increased even if it is a 1 number in order to get the minimum number as fixed by the law. If the interest directors is more than 2/3, minimum will be 2 disinterested director or a non-interested director who are present. Interested director, who are the interested director as per section 184 subsection 2. In case of body corporate, more than 2, he can be promoter, managing director, CEO of the body corporate. In case of firm, entity, partner, owner, member, he cannot participate in the meeting. In case of private limited company, interested director can participate after disclosing his interest, and they are not defaulted in filing annual accounts or annual records. Meeting could not be held for want of quorum. Adjourn next week, same place, same time, same day. National holiday cannot be done. Public holiday can be done. Exception OPC section 174. Thank you.